Have you ever wondered how lawyers navigate the massive, complex world of law to find a single specific answer? Well, today, we're pulling back the curtain. We're going to demystify that process, which might look like a maze from the outside, but is actually a very systematic skill.
I mean, think about it. When you have a legal problem, you need the answer, a precise one. But you're dealing with this vast ocean of laws, court cases, and rules. So how do they find that one needle in a haystack? It's definitely not luck. It's all about having a system.
And here's the system we're going to follow. First, we'll get a feel for the challenge, this legal labyrinth. Then we'll talk about the maps they use to navigate it, the framework that guides them, what research looks like in practice, and finally, how they build a solid case.
All right, so first things first, we really need to get our heads around why finding legal answers is nothing like our everyday Google search. It is a completely different kind of maze.
You know how it works with a normal search, right? You type in a few words and you expect a direct, simple answer. Boom. But in the legal world, those same keywords just crack open the door. You don't get an answer, you get the raw ingredients. Cases, laws, expert analysis, and, get this, even the arguments the other side might throw at you. Your job is to take all those pieces and build something with them.
So when you're facing all that complexity, where do you possibly begin? Well, smart researchers don't just wander into the maze. No way. They start with a map.
And that map, it comes in the form of what are called secondary sources. You could think of these as your expert guides. They aren't the law itself, but they're things like textbooks or legal journals that summarize and explain a whole area of law. They give you this fantastic big picture view and often point you straight to the most important stuff, which saves a ton of time.
And where do those secondary sources point you? Right here to the primary sources. And this is absolutely crucial. Primary sources are the law. We're talking about the actual court decisions and the legislation that can literally change someone's life. So while a textbook is helpful, it's only these primary sources that a court has to listen to.
This quote just nails the relationship between the two. Think about it. A doctor might read a medical textbook to understand a disease, but they have to actually examine the patient to make a diagnosis. It's the same thing here. A lawyer uses those secondary sources to get up to speed, but their final actual opinion has to be based on the primary law itself.
Okay, now that we know what we're looking for, how do we organize our thoughts? Well, lawyers use a specific mental model, a system to break down any legal problem they face. It's called the FILAC framework.
Let's break this down. FILAC, that's F-I-L-A-C, is basically a step-by-step guide from total confusion to a clear answer. You start with the facts, what actually happened. Then you frame the legal issues or questions. Next, you go find the relevant law. Then comes the most important part, the analysis, where you apply that law to your specific facts. And only after all that can you reach a solid conclusion.
All right, let's zoom in a bit on that L for law. How do you actually find the primary sources, especially the court cases you need? Well, that is its own little three-step process.
It's a simple rhythm, really. First, you have to find the right cases. Second, you have to read them really carefully to understand not just what the court decided, but why. And finally, and this one's a big one, you have to note them up to make sure they're still valid.
Now, that finding step, it's not happening on Google. Lawyers use these incredibly powerful, specialized databases, tools like Westlaw or LexisNexis. These aren't just search engines, they're sophisticated finding tools, built to let you search by legal concept or find every single case that has ever mentioned another case. It's pretty amazing.
So what in the world is noting up? This is the ultimate quality control step. See, the law is always changing. A case that was the gold standard back in 1980 might have been completely overturned by a higher court in 2010. Noting up is how you check a case's history to see if it's still considered good law. Citing an outdated case is a rookie mistake you do not want to make.
Okay, so after all that digging, the finding, the reading, the verifying, you've got this pile of relevant facts, issues, and laws. The final stage is the real art form, weaving it all together into a killer argument.
And you know, here's the secret to a really strong legal argument. It's not just about finding the points that help your side. It's about synthesis. You have to look at the problem from every single angle, especially from the other side's point of view. Why? Because that lets you anticipate their moves, spot the weaknesses in your own case, and build a position that's way more robust and persuasive.
So, let's just do a quick recap. The big takeaway here is that legal research is not some random, chaotic search. It's a methodical process. You start broad with your map, the secondary sources, then you zero in on the primary law that actually matters. The PHILAC framework is your guide for thinking through the problem, and of course, you absolutely always have to note up your cases.
This entire system we've just walked through, it's all built for the human brain, for human logic. But as powerful AI tools start to enter the legal field, you have to wonder, right? Will this whole intricate, human-driven process fundamentally change? Will that lawyer's map need to be completely redrawn? That's definitely something to think about.